And let me read
legislature did
something
with
to
this.
you. And this is not something that a judge wrote. This is something that the legislature wrote in its legislative intent section in the 2022 law. The legislature intends, through this act and any rules and policies adopted hereunder, to restrict the practice of non-therapeutic or elective abortion, not eliminate, but restrict to the period up to 15 weeks of gestation. That's what the legislature said its intent was a few months ago. How do we disregard that and instead adopt your view?
Because, Your Honor, I don't think that's inconsistent with my view.
Well, your view is that the 15-week law does not protect abortions conducted within 15 weeks. The legislature said it intends to restrict that practice to the period of up to 15 weeks, and I don't see how what you're saying is consistent with what the legislature said. I don't think anybody could have made that argument with a straight face.
I think they would have made that argument. Whether it would have prevailed or not, I'm not sure.
We're looking how the trial court got there. And the trial court expressly stated that she didn't believe that under the rule that she could consider the statutory framework, that she was limited to just a decisional law. That was a mistake. And isn't a mistake of law, isn't that an abuse of discretion in and of itself?
To exercise
but
her
the
discretion.
problem is, and that's the mistake of law, is that without citation, the Superior Court found that modifying the injunction to harmonize laws not in existence when the complaint was filed on grounds for relief not set forth in the complaint is procedurally improper in the context of Rule 60b-5. That's just not true.
Exercise of discretion effectively change substantive law? Because we're looking at two very different legal landscapes resulting from different possible decisions in this case. And you're saying that just because the trial court exercises its discretion not to engage in an analysis, the law is going to be one way versus another? That seems to expand discretion well beyond anything I'm familiar with.
Well, Your Honor, I think
it also seems to imply an elevated role for the judiciary in lawmaking that I very much doubt the legislature would support, or your client for that matter. Cited some offhand comment from Senator Bartow. How is any of that relevant to what the legislature actually passed?
so.
Any person, I think, includes women.
I would disagree with that. I think when a statute,
You might want to just stop and rephrase that.
when a statute adopted at the same time as 3603, 3604 covered the pregnant woman, I think that then is the statute that's applicable, and that statute has been expressly repealed by the legislature.
So we are then to interpret 3603 going forward as saying any person except women. Is that right?
Well, no, if a woman is a doctor and procures the abortion.
Okay, fine. Any person except a pregnant woman seeking an abortion is now what it means. Even though it doesn't say that, we're supposed to interpret it that way?
Yes, because of the express repeal, if that still applies with full force.
Yeah, but the only abortions that are going to occur that are lawful, that is, and in essence, the only ones doctors are going to perform, are ones that are necessary to save the life of the mother under 3603. So you're saying our legislature and this particular legislature that said we should give vitality to all these statutes is saying then when we got to do an abortion for the life of the mother, you better show her a picture of the sonogram so she feels good about that decision? Right? Is that what you're suggesting?
That's what the law says, Your Honor.
In interpreting theories of interpretation, avoid absurd results?
Well,
in other words, that's what the law says if we interpret it the way you want to. But if interpreted the way that the state is suggesting that we interpret it leads to a pretty preposterous result, shouldn't that give us pause that we shouldn't interpret it the way you're suggesting?